Good morning, dear friends. Today we are going to start a new topic under the Income Tax Act 1961. The name of the topic is Income from House Property. Income from house property is the second head of income of the SSC. We discussed the first head of income of the SSC, that is income from salary. So this is the second head of income. The provisions relating to the computation of income under this head, they are comprised in section 22 to section 27. But the scope of total income which is required to be charged under this head is defined under section 22. So we can say that the charging section is section 22, which defines the scope of income to be charged under this head, and the computation of income under this head is contained or governed by section 23 to section 27. This is a little introduction of this particular topic, income from house property. Under this head, the annual value of the property of the building and the land appertaining thereto, of which the SSC's owner is liable to be taxed. So this is the basis for charging the income under this section. It means the annual value of the property consisting of the building and land appertaining thereto, for which the owner is SSC, shall form the basis for charging under this section. Now, in general way, in general parlance, if you just think of taxable computation of income under this head, you will presume that there will be some house property. I mean, I'm just telling you the general presumption which you may think. There will be house property, and if a person is deriving any income from this house property, then it will be taxed under this head. But certainly this is not the whole story, this is not the whole content to be thought of for charging the income under this head. In fact, it is the annual value of the property which forms the basis for charging the income under this head, or for the purpose of computation of income under this head. It means there may be some of the cases when you are not deriving any income out of the property, but still the income shall be charged. It means your income will be subject to the tax. We will just discuss this thing in our subsequent discussions, but for the timing, I just wish to tell you that the scope of the concept of annual income means what exactly. I mean, these five lines will define the total scope of income to be charged under this head. The annual value of the property. So we just see the concept, what exactly is the annual value. Then we just try to learn the building and land appertaining thereto, because these are really very next thing, and we should take the building and land and appertaining thereto in combination with each other. And the third concept is the liability. Who will pay the tax? Obviously, under this act, the owner shall be liable to pay the tax under this act. So we just try to learn the basic concepts forming the basis for charging income under this head. The first concept is annual value. I just told you that in the ordinary parlance, the income from house property shall presume that you have got a house and for which you are deriving the income in the form of rent. But it is also possible in some of the cases that house property in question may not giving you or may not yielding you any return, and still for the purpose of income tax you would have income from house property. So what is taxed under this head is not the actual rent, but the capacity of the property to earn the income in the form of rent, and that is technically known as the annual value of the property. So we can say that the annual value of the property is not only confined to the actual rent, or actual income which is derived from the property, neither you can construe that annual value is confined to the municipal value or the fair rental value or the rental value of the property which may be adjacent to your property. In fact, the annual value is the inherent capacity of the property to earn the income, which is liable to be charged under this head, and this annual value is going to form the basis for charging the income under section 22. So this is all about the annual value of the property. Now we just try to understand the concept of property, because if you just see the first few lines which I just explained to you, the lines were: the annual value of the property consisting of building and land appertaining thereto, of which the assessee is the owner, shall be charged to tax. So we have just learned the concept of annual value. Now we'll just see what exactly is to be included in building and land appertaining thereto, and what exactly do they convey for the purpose of charging the income under this head. In terms of the provision of the Act, the property should consist of building or land appertaining to such building. It means, in terms of the provisions of the Act, the existence of a building is a must, is inevitable. So you can say this is the essential prerequisite for charging the income under this head. And the building, of course, may include the residential house. The residential house may be let out, or it may be self-occupied. It may consist of the office building, or a factory building, or a godown, or a flat, and for the purpose of which the building may be used by the tenant is also immaterial. Even if it means the building is being used by the tenant, it is not going to form the basis. Number 3, in respect to the office building must be surrounded by 4 walls. Means when you just talk of a building, it should be surrounded by the 4 walls, and the 4 walls may be of mud walls with roof, etc. But an incomplete building or a house in ruined condition without a roof and doors cannot be said to be building. So some specifications have been given in the Act about the building, particularly when it happens to be the residential building, the building which is meant for residential purposes. Now the next sentence is the opponent land in respect of residential building. This opponent land, because if you are just getting the rent from the land, he is just talking, the Act is very, very certain that the building or the land appertaining thereto, if you don't have a building and you are just deriving the income by giving on rent the building, and you are just deriving any income out of that land by virtue of your giving this land on rent, then this amount of income or this rent shall not be charged under this head income from house property. Rather, it would be charged either under the head income from business or profession or income from other sources. So here the Act is very clear. The building or land appertaining thereto, it means the land can be part of it. So the appertaining land in respect of residential building, it may include the approach roads, particularly when it happens to be the residential building, and it may include courtyards, it may include backyards, kitchen garden, playground, motor garage. So if that is there, then it would also be treated as a part of the building. It means this is the meaning of land appertaining to the building. In respect of the non-residential building, the car parking space or the road connecting one department to another department or a playground will also be construed as the land appertaining to the building. However, if the building or a part thereto is used by the owner himself for the purpose of his own business, then there will not be any income from such portion of the house property. Rather, such income shall be charged under the head income from business or profession. So this is all about the concept of the building, the concept of property. So again, I just try to sum up about the concept of property. First of all, the property should consist of the building and the land appertaining thereto such building. then the existing of building is a prerequisite. It means without building you cannot charge income assessed under this head, and the building may be a residential building or other than residential building. It may be warehouse, it may be factory building, office building, like that. And the land appertinent thereto, it may be appertinent to the building, maybe approach road, or it may be in the form of space for godown, or it may be a kitchen garden or backyard or something like that, or motor garage, courtyard. That can be anything. So that would also be treated as a part of the building. So now we just come to the third thing, which is also very, very important in that: who is going to pay the tax? The Act says that assessee should be the owner of the house property. So it is the owner who is liable to pay the tax on the annual value of the house property, whether he occupies the house or not. So the liability to pay the tax rests with the owner. So the assessee should be owner. Again, it is the owner of the house and not the owner of the land on which the house is constructed is taxed under this head. In case, for example, a person may be owner of house, but he may not be the owner of the land. In this case, it is the owner of the house who has constructed the house on the leased land. He shall be liable to pay the tax under this head. So the Act is very clear. It is not essential that you should be both the owner of the house as well as the owner of the land. If you have just constructed the house on a leased land, then as the owner of the house, you are liable to pay the tax in respect of the income which is assessed under this head. So we can sum up that some of the important points which emerge from the provisions of section 22 as we have discussed. The important points are that, first of all, the first condition is that the property should consist of any building or land appertinent thereto. This is the basic conditions. If you have got a land and there is no building at all and you are just deriving any income by way of rent from the land, certainly then that income shall not be assessed under this head. Rather, it would be taxed under the head income from business or profession or income from other sources. So this is the first condition. So the existence of building is a prerequisite for charging the income under this head. Number two condition is the assessee should be the owner of the property. It means it is the owner who is liable to pay the tax in respect of the income assessed under this head. Third is the property should not be used by the assessee for any business or profession carried on by him. It means if he is using this property by way of any business or profession, then the income shall not be charged under this head. Rather, it would be charged under the head income from business or profession. So, unless the aforesaid conditions are not satisfied, the property income cannot be charged to tax under this head, that is income from house property. So these three conditions are prerequisite for charging the income under this head. So for the rest of the provisions of this head, we shall discuss in the subsequent lectures. Thank you very much.